Good morning, everyone. Welcome to the March edition of Outline, DLA Piper's monthly planning law update. The format remains as previously. We will rigidly stick to an hour, and during that time, we hope to have about 45 minutes of discussion of some of the more interesting and topical developments in planning law from the last month. And then 15 minutes of questions and answers at the end. So please, if you have questions as we go along, please do use the Q&A box on your screen, and we will get through as many of those as we can at the end. As ever, what we try to do on Outline is to focus on the practical takeaways from the cases and the legislation, and trying not to be too law heavy, but more focused, as I say, on the things that you need to know from the various cases and legislation we'll be talking about today. I'm joined today by my colleague Pieter Claussen, who is an associate in the planning team, and Pieter will come on later. But before I hand over to Pieter, if I just begin with a quick roundup of legislation and a quick mention of the budget. So starting with legislation. The phase 2A of High Speed 2 has now been enacted. The legislation has been enacted, and we have the High Speed Rail West Midlands to Crewe Act 2021. It won't surprise anyone to know that what that legislation does is enable the construction of the railway from the West Midlands to Crewe, the clue being in the title. The various sets of regulations also set out on the screen in front of you. They largely set out a lot of the detail for the working of the specific regime that governs construction of the HS2 project, and very much mirror in most parts the previous 2017 Act, which enabled the construction of phase 1 of the route between London and the West Midlands. The phase 2B is yet to come. There will be further legislation in due course will be needed to take the line across to Yorkshire and up to Manchester from Crewe. That was all I was going to say on legislative changes. So if we can move on to the budget slide, please. Not technically legal, but we had the budget just last week, and there was quite a lot in it from the planning side. So I thought it was just worth giving a quick summary of some of the planning related matters that were covered in the budget and alongside the budget. The first of which was the announcement of the UK Infrastructure Bank. The bank is proposed to have quite a large amount of funding available that will be available to both public and private sector in order to finance infrastructure projects across the UK. The initial proposal is for the bank to have £12 billion of equity and capital available to it, and then also be able to make a further £10 billion of guarantee commitments. So quite a significant chunk of money available for those delivering infrastructure projects in need of finance. There is a policy paper published alongside the budget, so if you want more details on the bank, then there's a lot of helpful information in that, and I would point you in that direction. The second interesting part of the budget, I thought, from a planning perspective, was the announcement of Freeports. The government announced 8 Freeports in England and indicated that there would be announcements of further ports in Wales, Scotland, and Northern Ireland in due course. The Freeports have a number of benefits. The press has covered quite significantly the potential tax benefits of Freeport status, but there is a planning angle to it, in that the proposal indicates that there will be planning freedoms within the Freeports that are designated. No indication yet of what that planning freedom means, whether it's akin to the enterprise zone relaxations that we're familiar with, we don't know, so watch this space, but there will be a planning angle to the Freeport designations in due course. The last specific announcement I wanted to flag up was the Community Ownership Fund. This links to assets of community value, which have been with us for the best part of a decade now, since the Localism Act. The Community Ownership Fund sets aside £150 million to be made available to community groups by way of match funding in order to enable those community groups to buy local assets. In most cases, there's a limit of £250,000, although in some cases, in relation to sports facilities, the limit is increased to £1 million of match funding. I think I think it is relevant to planning in the sense that the assets of community value regime, one of the things that has perhaps limited its impact has been the fact that the consequence of an asset of community value or of an asset being designated as an ACV is that it can't then be disposed of, it can't be sold without first offering it to the community and allowing community groups the opportunity to buy it. We've seen this a lot with pubs, are a good example of buildings that have been designated as ACVs. The impact has been limited in as far as it's been dependent upon a community group of one form or another actually being in a position to be able to afford to purchase the asset when it comes to market. So I think we need to watch what happens with the community ownership fund, because potentially, whereas in the past, the answer has often been that the community group is not in the financial position to acquire the asset, it may be that this funding emboldens and makes possible some attempts to purchase ACVs. So if you have properties that are registered as ACVs, then it's worth looking at that fund and just thinking about whether it raises any consequences for plans you have for the asset moving forward. There were lots of other funding announcements in the budget, various funds being made available for town centre renewal, high street regeneration, and also various specific projects funding being announced for those, including improvements to the link across the Pennines. The road as was one of the road projects that was supported. So lots more specific detail, but those I think are the three that have quite a general applicability and maybe of interest to those listening. There we are. That was the budget in about 2 minutes, the budget from a planning perspective. So I'll now hand over to Peter, who is going to talk us through our first case this morning. Morning, Peter.
Thanks, Trevor. You'll see from the slide that the High Court's decision, they've provided a textbook example of how to apply Section 38(6) of the Planning Compulsory Purchase Act 2004 and the role of the planning judgment within that. And you'll see that I've copied the text of Section 38(6) onto the slide. But as we're all familiar with, the legislation requires that a determination under the Planning Acts must be made in accordance with the development plan unless material considerations indicate otherwise. Now, the Tame case that I'm going to talk about today is actually an example of where a material consideration can indicate otherwise. In this case, it was in relation to fallback development, or in other words, the planning position which is available to a developer, irrespective of whether a local planning authority refuses their application for planning permission for some form of other development. As we all know, it's well established that the fallback position can be a material consideration in the determination of planning applications. As with all planning cases, the court will not intervene where a decision maker is exercising their planning judgment, provided that judgment was lawful and specific to the case of fallback development, that there is a real prospect of the fallback development coming forwards. So moving on to the case itself, Tame Council, who are a parish authority in Oxfordshire, applied for statutory review of the Secretary of State's decision to grant planning permission to Angle to demolish an employment site and create a mixed-use development consisting of dwellings, office space, a care home, and this was at Kingsmead Business Park in South Oxfordshire, which itself had been vacant and had been for over a year before the application was made by Angle. However, the business park had the status of an existing employment site for the purpose of the local planning authority's development plan policies, which seek to resist the loss of such sites. And you'll see I've put the relevant parts of policy E6 on the slide, which was the main development plan policy in question. But essentially, it's the sort of employment site protection policy that we see up and down the country. And it requires that any change to a non-employment use will only be permitted if the site's been marketed at a reasonable price for at least a year and that its employment use is shown to no longer be economically viable. I think it's probably worth noting that Tame, who are obviously the claimants in this case, they had a neighbourhood plan policy that was very similar to policy E6 that's on the slide. But before making its application for planning permission, Angle didn't market the site as they were required to have done under policy E6. Instead, they marketed all of the site, save for an office building, and its rationale for doing that was that it already secured prior approval under permitted development rights for a change of use from office to residential, and so excluded this aspect of the marketing strategy it undertook as part of its wider application process. I think it saw this prior approval as its fallback position, and so didn't consider it needed to market that part of the site accordingly. The application itself initially had officer recommendation, but was then refused by the council's planning committee on the basis that it would result in the loss of an existing employment site without there being any adequate evidence to demonstrate that the site was no longer economically viable, essentially for a conflict with policy E6. Angle then appealed that decision to the Secretary of State, and on appeal, the inspector agreed with the council and concluded that the proposal was contrary to the council's development plan, because as the office had been excluded from the marketing strategy, it therefore hadn't been demonstrated that the whole of the site was no longer economically viable. But whilst the inspector found that conflict with policy E6, he concluded that the conflict was significantly outweighed by the fact that this office building benefited from the prior approval for residential development. I think this, in conjunction with the fact that the marketing strategy undertaken had proven the rest of the site not to be viable, and that led the inspector to conclude that the planning permission should be granted, notwithstanding the policy conflict. Effectively, he saw a comprehensively developed scheme as a superior option to a partially developed residential site with derelict and unviable adjacent office space. Now, as I mentioned earlier, Tame then challenged that decision before the courts, and interestingly, the local planning authority opted not to take part in those proceedings, and indeed rightly so, because the court found in favour of Angle. The inspector had fully understood and properly applied the policy. I think this is perhaps obvious when reading through the decision, because the inspector clearly agreed with the council insofar as he found that the development was not compliant with the policy as it failed to meet the marketing requirements. And actually the fact that there was this fallback position with prior approval had not even come into the inspector's reasoning when talking about policy. The prior approval part of the development only became relevant when the inspector applied his mind to whether there were any material considerations, which indicated that the planning permission should be granted despite this apparent conflict with the development plan. And in that respect, he was entitled to come to the conclusion he did and apply significant weight to a fallback position which had a realistic prospect of meaning that only half of the site would be developed. So to sum up, in the words of section 38.6, the inspector applied significant weight to the material consideration, which in this case was the fallback position, and then went on to conclude in his planning judgment that it was enough to indicate that this particular determination didn't need to be made in accordance with the development plan.
I think, as you say, Peter, that's a real sort of textbook case of how section 38.6 should work. And it's interesting that the approach that the applicant had taken initially was to try and crowbar the proposal into compliance with the policy. And it's interesting that they almost tried too hard with that. And it's a reminder that sometimes, to my mind at least, it's a reminder that sometimes you're better just to take a conflict with policy on the chin, acknowledge it, and then go on to justify why those material considerations outweigh that conflict, perhaps.
Yeah, I think that's right. Actually, I think actually both probably the applicant and the council, and latterly Tame Council, probably showed a lack of understanding of the operation of section 38.6, because the council and then later Tame, I mean, they were only concerned with policy, and they weren't prepared to consider what was quite obviously a material consideration in respect of this fallback position, and that needed to be weighed up in the planning balance, but had actually been completely ignored in favour of a rigid application of policy.
As you will remember as a former trainee of mine, and as all trainees of mine over the years will remember, 38.6, it's the beginning and end of everything in planning. ingrained into all my trainees for as long as I can remember. You've put on the screen, Peter, that a caution and a reminder not to place too much reliance on the views of an officer. What was the point there in the case?
Yeah, indeed. It would seem that this case all came about because a planning officer had originally advised Angle that they didn't need to include the employment land within the application originally because of the fallback position which they had for the prior approval. I think it's just a timely reminder that the word of an officer during the application process carries little to no weight at all. And actually, the case law has been clear on this for some time, but it's always worth remembering that anything an officer says during an application can then be overturned by committee and then debated at length in front of an inspector, and then ultimately, as in this case, the courts.
Great. Okay. Thank you, Peter. If we move on to the next case then, which is one that I wanted to talk about, quite a lot going on in this case. But it's the City and Country case, hot off the press. The judgment was only handed down by the Court of Appeal 2 days ago, so it's shiny new. Quite a complicated history. We don't need to go into a lot of it, but the site is Bramshill Park in Hampshire, which is a former national and international police training college. As I say, complicated facts and quite a remarkable number of appeals that were before the inspector for determination in these proceedings. There were 33 separate appeals that the inspector had to determine. So she had quite a tough job on her hands getting through them all. I think in terms of the key facts, the Bramshill Park itself is a Grade 1 registered park and garden, and within it, the main building for the former college is itself a Grade 1 listed Jacobean mansion. There are also various other buildings within the registered park. There were several proposals before the inspector in the alternative for various changes of use of the manor house and the attached stable block. There were also 26 separate appeals against enforcement notices that had been served in respect of individual buildings within the site that were alleging unauthorized changes of use. But in fact, by the time the case came to the Court of Appeal, they were concerned with just 3 appeals. And those appeals in total were proposing 258 dwellings, some of them in replacement for some of the existing buildings on the site, and others to be provided within the site elsewhere. The inspector had refused those 3 appeals, and City and Country took issue in the proceedings with a number of her findings in connection with those 3 appeals. For me, the most notable aspects of the judgment are concerning the criticisms that City and Country made of the inspector's decision around how to apply MPPF 79, paragraph 79 of the framework, which warns against allowing development of isolated dwellings in the countryside. And also City and Country took issue with how the inspector had applied the NPPF heritage policies. So starting with paragraph 79, the rural policy aspect, and I should say the case was considering the 2018 edition of the framework, although both the wording in MPPF 79 and the heritage policies haven't changed in the 2019 framework. So I think that the judgment is applicable and relevant moving forward to the application of those policies in the new version of the framework. But in the context of Para 79, the inspector had found that the proposals would result in isolated dwellings in the countryside. And so given that none of the exceptions that are contained in paragraph 79 applied, she found that there was a conflict with the framework in that regard. City and Country effectively argued that the proposed dwellings could not be isolated, and in doing that, their argument, in summary, there was some nuance to it, but in summary, what they were arguing was the fact that the new dwellings were proposed to sit next to existing buildings, and indeed the fact that there was such a large number of dwellings being proposed in total meant that any one of those dwellings couldn't be isolated by definition, because they were next door to something else, even if that something else was part of the new proposed development. In making that argument, there was some precedent in previous cases which suggested that they may have a point in terms of that argument, but in this case, the Court of Appeal did not agree and rejected the argument put forward by City and Country. And I think in doing that, the court expressly recognises that if City and Country were right, then the only thing that would be prevented by paragraph 79 would be a single dwelling built in isolation and not near anything else. And the court clearly felt that that was not the intention of the policy. The policy was intended to prevent more development in the countryside than just single standalone dwellings. I think coming to that conclusion, they'd had regard to paragraph 72 of the framework, which indicates that whilst there is a case for larger scale new settlement development being planned for, paragraph 72 indicates that that's something that ought to come through the plan making process rather than sort of opportunistically through applications for specific planning permissions. And so in that context, the court were very comfortable that 79 was supposed to prevent more than just single dwellings. So instead, the approach that their lordships took was consistent with an earlier decision from 2018 in the Braintree District Council case. Now that case had looked at similar issues, but in the context of the 2012 version of the framework, and the wording has changed a little between the two. But the court held that it hadn't changed the principle, and therefore they followed their earlier judgment in the Braintree District Council case. And so the consequence of the case is that when one is considering whether a proposal does lead to the creation of new isolated dwellings in the countryside, the test that should be applied is that which I've set out on the first bullet on the screen, i.e. that the decision maker has to consider whether the development would be physically isolated in the sense of being isolated from a settlement. And I think the critical point on this aspect of the judgment for everyone to take away is that when considering that test, their lordships were clear that both the question of what constitutes a settlement and the question of whether the development is isolated from that settlement are both matters of planning judgment. And so the court wasn't prepared to give any guidance on what a settlement is or what isolation means. They were content to rely on the ordinary meaning of those two words and to leave the matter to planning judgment in each case, leaving it to the discretion of the decision maker. Therefore, in this case, they were content that the inspector had been perfectly entitled to form the two judgments that she had. Firstly, she had concluded that the existing buildings on the site did not constitute a settlement, and therefore the proposal for new development would indeed be isolated from the next settlement along, and therefore the court upheld her decision that there was a conflict with paragraph 79 of the framework. So if you are considering development outside of settlement boundaries, development in the countryside, and you're looking at the application of paragraph 79, then there's some very clear guidance in this case as to how to go about that. And ultimately, the answer is it's a matter of judgment. The second point that I think is particularly interesting was on heritage. Heritage seems to be a never-ending source of case law and source of challenges to planning permissions at the moment, and this is just another example. But in this case, obviously there was heritage aspects with both listed buildings and the registered park being part of the site. And in each of the three appeals, the inspector had identified that there would be harm to the significance of those heritage assets. And what she'd then done is, having found that there would be harm, she'd then gone on to apply the appropriate balancing exercises in MPPF 195 and 196, depending on the level of harm that she had identified in each case. Now, at the inquiry, City and Country had argued that the inspector shouldn't take that approach. What they had argued was that she should begin by looking at just the heritage impacts, the beneficial heritage impacts and the adverse heritage impacts, and conclude on that as to whether there was, in totality, whether there was an overall finding of harm to the significance of the heritage asset or not. And having done that, only then go on to apply the balancing exercises in 195 and 196 of the framework if the conclusion of that preliminary exercise had been that there was some harm, whether substantial or less than substantial. And City and Country had some precedent for making that argument. They were relying on the previous case of Palmer from 2017, and in the Palmer case, the planning officer had done precisely that in the context of a planning application. The planning officer, in his report to the committee, had identified that the proposal would have both adverse and positive impacts on the significance of the heritage asset. And effectively, his conclusion was that when you considered them and effectively netted them off against each other, there was no overall harm resulting to the significance of the heritage asset, and therefore there was no need to go on and imply either 195 or 196 and the rest of the heritage policies in the framework. So City and Country were relying on that decision in Palmer, where the court had held that the planning officer's approach was entirely justified. They relied on Palmer and said that that was the approach that the inspector ought to take. The inspector in this case, though, had considered the approach in Palmer, and she had concluded that it wasn't an appropriate approach on the facts of this case. In part, that was because what City and Country were looking to do was to take heritage benefits in the context of some of the other appeals that were before her and trying to add those into the balance. And her view was that on the particular facts of this case, that was not an appropriate way to do it. And so her preference was to proceed straight to the MPPF policies and to place both the heritage and the other public benefits into the balance against 195 and 196. The court was asked to consider whether she was right to do that or whether she had been obliged to follow the Palmer principle as it was put. And their lordships again ruled that the inspector had been entirely justified in taking the approach that she had. So the consequence of that is that the court were very clear that whilst Palmer is good law, and the approach that the planning officer had taken in Palmer and carrying out that initial balancing exercise is entirely lawful if that is how a decision maker reasonably decides to do it. Whilst that's acceptable, it's not the only way of doing it, was the court's decision, and therefore the inspector, having chosen not to follow Palmer and having chosen to go directly to the MPPF policies, was perfectly entitled to do that. So I think in heritage terms, the takeaway is just a word of caution. Whilst the Palmer approach can often be helpful, and the reason it can be helpful is because it avoids triggering. If you can in that initial assessment conclude that there is no overall harm, it avoids triggering the heritage policies of the framework, which means that the tilted balance can be engaged in accordance with paragraph 11. So there's quite often an incentive for applicants for planning permission to try and adopt the Palmer approach. That's fine. It is an appropriate approach if the decision maker agrees that it is appropriate in that context. But I think the word of warning that comes from a heritage perspective here is that Palmer is not binding on a decision maker, and ultimately it will be a matter for him or her as to whether or not to carry out that initial exercise first, or to just go straight to an application of the MPPF heritage policies and the balancing exercises therein. They were my sort of two main takeaways from the case. Peter, any thoughts?
Well, I can see from your third bullet, Trevor, that the relevance of the fallback looks like it was also considered in this case. Yeah. There's clearly a theme developing with this morning's cases. The fallback here. So in this case, it was the fallback was being used by City and Country as an argument to justify the sustainability of the site, and they were particularly focused on the question of greenhouse gas emissions.
and they had provided evidence that the greenhouse gas emissions for a residential development here would be lower than the greenhouse gas emissions that had been produced previously by the training college use. And part of their evidence for that was the international aspect of the training college use and the fact that people would have been flying in to attend courses at the college, and that would have had a significant impact on greenhouse gas emissions. So during the course of the inquiry, the council's witness under cross-examination had accepted that that was correct and that greenhouse gas emissions would be reduced by a residential development rather than a return to the fallback of the training college use. The inspector actually rejected that argument, although by the end of the inquiry, both sides agreed that that was the case. The inspector in her decision had indicated that she did not feel that there was enough information in front of her as to the greenhouse gas emissions that had been produced by the previous use to be able to come to a robust conclusion on the point. So she was saying a lot of it had been done by assumptions as to what would have been the use, the greenhouse gas emissions from the previous use, and she was uncomfortable with that. So she, whilst the parties had agreed to the point, she disagreed and said there was not enough evidence on it and therefore didn't consider it to be part of the sustainability question. And she then went on to consider sort of more traditional definitions of sustainability around lack of accessibility to public transport and such like, and had concluded that the proposal therefore was not sustainable in a planning policy sense. So it was interesting in that sense, I think, of sort of an example of where even if a matter is agreed between the parties at appeal, that doesn't mean that an inspector is obliged to reach that conclusion. Ultimately, he or she needs to reach their own judgment, and they're perfectly entitled to disagree with the position that the parties have reached, as long as the reasons for doing so are clear and intelligible.
It's interesting to see greenhouse gas emissions point featuring prominently again. I think it featured in two of the cases you covered back in January as well, didn't it?
Yeah, it did. It came up in the Heathrow Airport case, which we talked about in January, and also the case where there was a challenge to EIA on the basis the EIA for an oil extraction facility hadn't taken account of the carbon emissions that would arise when the oil was ultimately burned in whatever use it was put to once it left the site. So yes, you're right, Peter. I think it seems as if it is a growing area of challenge and a growing factor that is coming into planning decisions is the specific question of what are the carbon emissions, what are the greenhouse gas emissions that arise from development proposals, and how does that feed in to the more traditional view of sustainability. I think in a planning sense, sustainability has not traditionally been seen as a question of emissions beyond sort of air quality issues. But you're quite right. I think it's certainly creeping in and is something that moving forward, as people bring development forward, we're going to need to be thinking about how we present the greenhouse gas impacts of particular development projects.
Excellent.
Right, we've got about 10 minutes left, Peter, for us to do our next two cases, which I think we can probably just about do. So over to you for your next one.
Yeah, well, I can quickly run through this one, as it simply confirms something that we've known for some time, and that's that there's no legal requirements for a Section 106 agreement to bind all interests in the land to which the agreement relates. In this particular case, that the landowner had objected to the validity of a Section 106 agreement on the basis that they owned around 50% of the land, which had been included within the Red Line Plan in the Section 106 agreement. But the council had granted planning permission, notwithstanding that party's absence from the agreement. Ultimately, the court found that the Section 106 of the Town and Country Planning Act does not require all landowners to be a party to the agreement. The agreement itself in this case followed the requirements of Section 106. That's to say that it was in the form of a deed, it identified the land in which the person entering into the obligation had an interest, and as well expressing the intention of that party to bind their interests in the land. And the court held that the claimant hadn't been excluded from the agreement, and actually that it remained open to them to unilaterally bind themselves into the agreement at any time in the future.
Yeah, it always surprises me how often that becomes an issue in the negotiation of a 106, because it is very clear you don't have to bind all landowners. Clearly, a planning authority needs to make sure that the relevant landowners are bound so that the development cannot be carried out without complying with the obligations in the 106. But as long as that's been demonstrated, then that ought to be enough. But it is a common issue. Interesting here, looking at the reference, it was an extempore judgment, which means that usually in planning cases, the judge will hear the case and will then retire and will think about his or her decision and will issue the judgment often several weeks later, having had time to think about it. But in this case, that didn't happen. The judge literally heard the case and then delivered the judgment. So it was obviously a pretty clear case from his perspective. That it's an open and shut case. It is not a requirement that every single landowner has to sign a planning obligation as long as the requirements are met. So a useful reminder. The last case then that I just wanted to flag up, if we can go on to the next slide, please. This is a case where I have to say I can't help but feel sorry for the promoter of the DCO in this case. Anyone who's ever promoted a DCO will know that it's not an easy and certainly not a cheap process. And so, having no doubt spent easily a seven-figure sum securing development consent, they've had it taken away from them at the last minute, and really down to an inexplicable mistake that appears to have been made by both the examining authority and the Secretary of State, and no fault at all of the promoter. I've set the facts out on the screen. I don't need to go through them in great detail, but in short, the case concerns the Norfolk Vanguard offshore wind farm, and in particular, the connection of that wind farm into the national grid and the substation that was needed. The significance of the substation was that it was proposed in due course to also be the connection into the grid for the Boreas wind farm that was due to be the subject of its own DCO subsequent to the examination of the Norfolk Vanguard project. I think the key is that the EIA looked at the cumulative landscape impacts at that joint substation site, and it concluded that there was going to be a significant cumulative effect. And critically, the ES didn't indicate that there had been any difficulty for the authors in assessing cumulative effects due to a lack of information. And that's relevant because it's something that is expressly provided for in the infrastructure planning EIA regulations of 2009, which are the EIA regs that apply to DCOs. So having assessed and having identified a significant cumulative effect, I suspect it came as much of a surprise to the promoters of the scheme as it did to everyone else when the Secretary of State's decision was published. And both the Secretary of State's decision and the examining authority's report that was published with it had both concluded that there was insufficient information available to them to allow them to conclude on the cumulative landscape effects at the substation. And therefore they had deferred that consideration until the examination of the Boreas DCO itself. So they'd simply decided not to consider the question of cumulative landscape impacts at the joint substation. There's no explanation of why they reached that conclusion in either the examining authority's report or the Secretary of State's decision. And so it is rather strange, because the court, the evidence before the court was that there had been no suggestion throughout the examination process that there was any difficulty or any insufficiency of information on cumulative effects. So everyone had been proceeding on the basis that there was sufficient information and that the information showed that there was a significant effect. So unsurprisingly, the court quashed the Secretary of State's decision to make the order on a number of grounds related to that point. And I think ultimately the decision turns on its facts, and so is probably of limited interest in itself. But the judgment was given by Mr. Justice Holgate, who is the lead judge in the planning court, a very experienced, very senior judge. And the judgment contains a very broad review of some of the leading cases on the correct approach to EIA, not just in a DCO context, but also in a 1990 Act context. And so the reason I wanted to flag it was really because I think anybody who is involved in the writing of environmental statements and is wrestling with the issue of cumulative effects, it's worth an hour of your time to read the judgment, not because of the facts of the case and not because of the overall conclusion, but actually there's a great review in there of the whole gambit of EIA case law, and a good overview for anyone wanting to remind themselves of the legal principles that are in issue. So some required reading for authors of environmental statements. There we are. That's your homework from this morning's session. So that brings us to the end, I think, Peter, of what we were going to say. So we go to the Q&A. Firstly, Peter, I've had a question on the Tame case that you were talking about previously, and a question as to whether there's any relevance of the case to the recent change to the use classes and the introduction of the super E use class.
Yeah, I think the introduction of use class E will have an impact on the fallback position, in the sense that the scope of the fallback is now significantly wider under Class E than we recently had with well, in the case of the Tame case, B1 officers. Personally, I don't think the Tame case has told us anything we wouldn't have said previously in terms of the ability to fall back on permitted development rights, but it's certainly timely in the context of the consultation surrounding the new use class E. And as I'm sure you're aware, MHCLG ran a public consultation throughout December and January, which amongst other matters suggested a new permitted development right to change from new use class E to residential. I think this is particularly interesting given the wide range of uses which now fall within use class E. I mean, you've got retail, financial and professional services, health centres and industrial processes. And it's clear from the consultation that there will be a prior approval process for any residential development, but once any prior approval is secured, it does certainly widen that fallback position for any residential development using permitted development rights. And this could then be applied perhaps to sites which are seemingly otherwise protected by employment policies, as we saw in Tame.
Yeah, it's good. It's a good point, and I think there's another question looking at sort of the proposals, the proposed PD right rather to change from Class E to residential, and I think that really sort of builds on the point you're making there, doesn't it?
Yeah, absolutely. I think it does.
Yeah. We've had a question come in on. Again, they're all coming in for you today, Peter. You're having to work hard. I'm getting a morning off. A question around your point about not relying on oral advice from planning officers. The question is, what about formal paid for pre-application advice from the planning authority? Can we rely on that?
I think it's with anything, you need to approach it with caution. It's not gospel because planning is a public concept, so everything is open to public scrutiny. And ultimately, I mean, I suppose this is best shown when it goes to a planning committee at the end of it all. So yes, to an extent, it should be pointing you in the right direction, but certainly not to be taken as gospel.
It's ultimately the planning committee will determine, and it's the planning committee's view that ultimately is binding, isn't it? So I agree with you on that. I think on sort of that question of informal advice, the several years ago now, the Preapplication case looked at this question in the wider context of a situation where you've asked the question of the planning authority, do I need planning permission for this, or is what I'm about to do lawful? And having received an informal response from an officer, maybe on letterheaded paper and signed on behalf of the council saying, no, you don't need planning permission or whatever. And the Preapplication case was making the point that is of itself is not binding on the planning authority. And the logic of that case was that there are statutory processes available to get definitive answers to those sorts of questions. So, and that's particularly the Cluid and the Clopud regimes, the certificates of lawfulness. And so what the court said was, if you choose not to use that statutory process to get a definitive answer and instead rely on the informal view of an officer, then that can't subsequently be sort of held against the council and doesn't bind the council. So it's always important when you're getting answers to questions from planning officers to think about whether you need a more formal process to get a definitive answer that can't be rowed back on. Another one on the Tame case, Peter, a question around you're popular this morning.
It's a popular one,
yeah. A question around the relevance of Article 4 directions to the question of the fallback in that case.
Yeah, it's a good point, and certainly local planning authorities do have the ability to impose Article 4 directions to disapply rights in relation to specific types of developments. But I think there are a few reasons perhaps why local planning authorities won't at least easily be able to sidestep the new PD rights with Article 4 directions. The first that springs to mind is because of the potential compensation exposure, because actually, unless an Article 4 direction takes effect at least a year after it was first publicised, an authority can, in certain circumstances, be liable to claims for compensation where an applicant can show that they've suffered damage as a result. And just building on that, as a matter of principle, it's not possible to impose an Article 4 direction before the relevant permitted development right takes effect. And we anticipate that these new PD rights in one form or another will go live on the 1st of August this year. So the earliest a local planning authority can get Article 4 directions in place without that compensation exposure is 12 months after that date. Now, of course, we may see transitional provisions which protect local planning authorities in that respect, but we'll have to wait and see on that one. I think, secondly, for me, certainly, there's a clear desire from the government for more housing, and for a significant proportion of that to be delivered through permitted development rights. And I think this is plain from the recent consultation on proposed changes to the MPPF. Which actually specifically seeks to limit the use of Article 4 directions, and specifically says that they should only be used for the smallest possible geographical areas and ensure that they're mainly actually reserved for exceptional circumstances. So I think actually off the back of that, we might start to see more resistance to Article 4 directions, and whilst they don't have to be approved by the Secretary of State, he can intervene where directions are inappropriate, and we may just see more interventions given the clear desire excuse me, to deliver housing through the use of permitted development rights. And I think lastly for me on this Article 4 direction point, the general scope of use Class E means that it could actually be quite difficult to prevent permitted development in any event because of the fallback option that we discussed earlier. For example, an Article 4 direction may prevent the change of use from office to residential use, but there would be nothing preventing, say, an office from moving within use Class E to, for example, a day nursery, which of course would then not constitute development. And then the ability would be open to make the use of that permitted development right to residential. I caveat that slightly because there was at least a question in the consultation as to whether automatic use switching should be allowed within use class E. But to me, I think it would be a backward step not to allow this, because there's clearly a direction of travel here from the government. So it'd be an odd move to make using permitted development rights less accessible. And actually, I fail to see the rationale behind making use class E so wide in its scope if you're then going to require some form of other permission to prevent movement within that class. It kind of defeats the point for me.
It is a really odd question, I think, in that government consultation, that suggestion that there may need to be limits on the ability to move within use class E. The whole point of the use classes traditionally has been that any change within a use class is not a material change of use and therefore doesn't require planning permission, whether that's permitted development right or an express planning permission. So it does seem slightly odd that having made the decision to put all of these uses in one use class, there's now a sort of at least a thought in government that they might now need to put some barriers in. Well, in which case, why did they all go into one use class in the first place? That sort of feels like there may be a little perhaps a questioning of whether the creation of such a wide use class was the right thing to do in the first place, maybe that the government is reflecting on. But I guess we'll have to wait and see when they respond to the consultation. We've had a question come in. You'll be delighted to know this one is not for you. This one is for me, and it pulls together actually both of the cases that I've spoken about this morning. And it has been pointed out to me that in the City and Country case, the court had indicated that the inspector was allowed to reach the conclusion that whilst the parties agreed that the greenhouse gas position would be better than the fallback, she was allowed to come to a different view, whereas in the Pierce case, the court has not allowed the Secretary of State and the examining authority to come to a different view on whether there was sufficient information in front of them to decide the cumulative impacts of the landscape character changes. I think the reason for that is in the City and Country case, the inspector had explained why she had come to a different view. And so what she said was that she felt that the fact that there were lots of assumptions about what greenhouse gases would have been emitted by the previous use meant that evidence was just unreliable, and therefore she was not persuaded by it and not willing to place weight on that evidence. I think in contrast, and it's kind of good contrast actually, because in contrast, if you look at what happened in the Norfolk Vanguard case, there is simply a line in the examining authority's report that says there is insufficient information to be able to assess cumulative impacts at this stage. And there's no attempt to offer any explanation as to why the examining authority and then the Secretary of State reached that conclusion, given that everybody else involved in the examination process had been content that there was sufficient information in front of them. So I think it comes back to that question. In many ways, it comes back perhaps to the question of the need to give reasons for your decision. And if you are disagreeing, whether it's with a previous inspector's decision or whether it's with the evidence that's put in front of you, then you need to articulate clear and cogent reasons as to why you have reached a different conclusion. Had the examining authority and the Secretary of State done that, then there may have been a different outcome. I think there would still have been issues with the requirements of the 2009 regulations. I think there still may have been a lawfulness point, given the particular way that the legislation is phrased and given the particular way that the scoping opinion had identified cumulative impacts around the substation as being needing to be subject to EIA. So there may still have been a problem, but certainly the reasons part of that decision would have gone away had the examining authority and ultimately, most importantly, the Secretary of State, because it's his decision that was being challenged, had they actually expressed or given an explanation as to why they'd come to the conclusion they had, despite the evidence that was provided at the examination itself. So there is a logic, there is a consistency there, although it perhaps isn't immediately obvious. And I think just running down, I think that's all the questions we've had in. So we, on that basis, can draw today's event to a close. If I can just thank Peter for joining me today. If I can thank all of you for joining, I hope it's been useful. We'll be taking an Easter holiday next month, so we won't have an outline in April, but we will be back in May with an update of everything that happens between now and then. So in the meantime, have a happy Easter, and look forward to seeing you all again in May. Thank you. Bye-bye.